For over 30 years, we have been delivering you the most trusted, comprehensive, intelligent, and up-to-date news across every sector, every platform, every day. Our uniquely integrated data and insights platform bolsters your business development, strengthens your research, and drives your decisions. Our events inspire innovation within the Western Australian business community, celebrating leaders, entrepreneurs, and trailblazers. At Business News, we believe progress boils down to one simple habit. That is, what you subscribe to today shapes what you become tomorrow. Subscribe to success. Subscribe to Business News.
Hello and welcome to our Legally Speaking webinar brought to you by Business News and Pragma Lawyers. I'm Mark Beyer, Senior Editor at Business News, joined today by Aaron McDonald, Founding Director of Pragma, and Nick Malone, Fellow Director. Good to have you fellas. How are you today?
Thanks, Mark.
Good. So look, it's been 10 years since Aaron opened the doors at Pragma Lawyers, and in recognition of 10 years, the theme today is 10 tips for protecting your business.
Yeah.
So for starters, Aaron, just tell us a little bit about opening the business and how it's gone.
Oh, well, it's grown quite considerably. It was just me back then, Mark, just one person, but now we have about 27 lawyers, 40 staff, 15 different practice areas, mining, insolvency, employment. So it's quite a multi-dimensional business now. It's grown all organically. So I'm very fortunate and happy and looking forward to the next 10.
Yeah, and I think you've always tried to do things a bit differently. I mean, the fact that you're based in Subiaco, for starters.
Yes. Well, I'm completely biased about Subiaco, and you can't get an objective opinion about it because I love it so much. I'm born and bred. I was born at the hospital at the end of Rockaby Road. Grew up in Subiaco, lived there, worked there. So I like it there, and we're trying to do things differently than the terrace.
Yeah, okay. Well, it's obviously working for you, judging by the growth of the firm.
Yeah,
okay. Well, look, let's get into the 10 tips. And number one, resolve disputes in a timely manner. So I think, Aaron, a lot of these things might seem obvious, but people forget them sometimes.
Yes.
And this is a good one to start with.
These 10 tips, they seem probably overly basic, and to lawyers they will be, but I often find when speaking to clients, I mention them to clients and they're like, oh, I didn't realise that. And they're ideas that are firmly ingrained in the way that we practice law at our firm. We always try to sort of espouse these virtues. So the first one about resolving disputes in a timely manner, no person ever wants to be in a commercial dispute with another party. But the truth of the matter is there's clearly a correlation between resolving things quickly and getting a good result and paying your lawyer less effectively, because the longer that they're involved, the more they're going to charge you and it gets out of control. Statistically, only 3% of cases when there's a dispute go to a final trial. But one thing that's really important is to try to get disputes mediated or negotiated, or try to get an outcome as soon as possible. Easier said than done, but as long as you're always trying to do that, then I think that's always in the client's best interests.
Okay. And one element that can take up a lot of time is the discovery process.
Yeah. So that's traditionally, I think statistically, the area where lawyers have traditionally generated the most revenue. You hear stories about big law firms with 40 lawyers working on discovery tasks with thousands of documents. But the truth of the matter is with the discovery is that in the cases that I've been involved in, it often only comes down to 5 or 10 documents, that are the key documents of the case. And courts now, judges are so reluctant to allow lawyers to spend hours and hours doing large discovery tasks. They'll refine it down and require the parties to give discovery by what's called categories. So what Nick and I do a lot with disputes is we always try to avoid the discovery process altogether by getting to resolving a dispute early. But when you are faced with having to do discovery, it's better to just try and keep it as simple as possible.
Okay. And the second one is about being pragmatic and proportionate, because I've certainly reported on a number of cases where it would appear emotion gets in the way
100%.
of common sense.
Yeah, so often you have clients who come in to the firm and they say, Aaron, it's the principle. You know, this is the principle. This isn't about money, it's the principle. And it'll be about, don't get me wrong, it'll be about a significant amount of money. Say, for example, a dispute over not being paid $100,000. To anybody, that's a significant amount of money. But once you start spending money on lawyers for 6 months, 12 months, 18 months, the proportionality gets completely out of whack. Sure, spend significant money on lawyers when the disputes are over mining royalties and the like, but you need to sort of have the correct solution tied to the proportionality of the dispute. And the courts are always talking about making the amount of time and effort that the parties and the courts and the lawyers put into a dispute proportionate to what's at stake.
And so some people might just need to suck it up and make a concession for the longer term benefit.
Yeah. I mean, I think that it's often a hard job as a lawyer to give your client that open and frank advice. You say, listen, I hear what you say, and we can do things on principle, but the truth of the matter is you want me out of your life as quickly as possible. So let's try and focus on doing that and just trying to steer them in the right direction. And sometimes you just see, from an outsider looking in, that doesn't seem to be the case of what's happening.
Okay, rightio. Well, look, moving on to our third tip, get an expert. So Nick, are there still people out there who think they can do it themselves?
There certainly are, Mark. So what you find in the law, and if we equate it to something like the medical industry, when you go see a lawyer, you don't know whether you're going to go see a GP or you're going to go see a specialist in the area. So just like the medical industry, if you go see a specialist, sometimes they'll cost a little bit more. But what you find is they'll diagnose the problem quicker and they'll find the solution quicker as well. And that's certainly the same in the law as well. You can find generalist firms that will offer you the wide range of services all the way from criminal matters to family matters to commercial disputes to wills and estates. But we find, especially with the lawyers that we come up against from time to time, the ones who are specialists in the areas that they actually operate in are better at what they do, and they're actually more conducive to getting a settlement for the parties with and through. So we certainly would suggest, if you've got a particular type of dispute, seek out a lawyer who does that type of dispute more often than not, if not all they do.
And is that something where you would help the client to find the right person?
Absolutely. So I think part of the reason the firm's been able to grow over 10 years is the ability for us to say, if we're not the right people for you, we'll certainly put you in the right direction of the people you need. And I think that's, to be fair to most of the lawyers in Perth, the sort of collegiate aspect that a lot of them have, which is to say, if it's not me, I'll know who to send you to. And certainly if a client has a first meeting thinking they're with the right person, but they walk out of that meeting thinking maybe not, we'll come to it by getting a second opinion, but also just asking the lawyer, if I wasn't going to engage you, who would you recommend?
Okay, rightio. Tip number 4, a pinch of prevention is worth a pound of cure.
That's an old line. It was the former Chief Justice Wayne Martin who used to use that line. And what he meant by that is that when you go to see a lawyer, you want to, and we often joke as lawyers that in commercial law, there's 2 types of lawyers that you can go and see. And one's the lawyer that you want to go and see, and one's the lawyer you don't want to go and see. The lawyer that you want to go and see is the transactional lawyer, the lawyer that's going to help you sell your business, buy a business, list your company on the stock exchange, buy a gold mine or something like that. The lawyer you don't want to see is, I'm getting sued for this amount, I want to sue this person for this amount of this issue's arisen. The truth of the matter is, like, to engage a lawyer to properly document an agreement at the outset when all the parties agree and are on the same side is so drastically less than the cost of engaging a lawyer when a dispute arises about what the terms are. So it's often hard to sell to clients that, you're probably worth spending a few $1,000s documenting this properly at the beginning so everybody understands, so there's no grey down the dispute, because I see it all the time with 50-50 business partners that have gone into business with each other, the business has taken off, they've been very successful, they own the company equally, and the first question, they walk into your office and they say, listen, I'm not getting along with my business partner. The very first question you ask is, did you get a shareholders agreement done when you set up the business? Go, we thought about it, but we never did it. And all of a sudden, it's lawyers sending letters back and forth to each other. And trying to determine how to divvy up the company or resolve the issue. So I can't stress this one enough. It's really important.
Okay. Is it comparable to the scenario many people might be familiar with about having a will?
Yeah, exactly.
A properly written, carefully drafted will.
So true. And in fact, there's one judge, he's recently retired, but he used to write in his judgments, he wrote it a few times, that those home will kits that you can buy from the post office, that you write, he said he described them as a curse. And because people think, I'll just do my will and I'll do it myself, it's easy. I've got pretty simple assets, I own a home, I've got some super or something. But the truth is, there's a lot of things to think. Wills are not expensive to get a will. A simple will cost, if you go to a lawyer, cost you $500. You know, it's probably one of the cheapest things you can ever do with a lawyer. But it's so important to do properly and document correctly, because as we've seen, and there's been some high profile disputes over wills that your publication's obviously reported on a far greater scale, but the court has so many of those disputes running through it, and obviously once the person dies, you can't actually ask them what they intended with their estate. So yeah, it's not a good place to be.
Yeah. Okay. Rightio. Tip number 5, and look, I've got to say this one surprised me a little when I read this. To avoid advice in writing if you wish to reduce expense.
Yeah. So I must stress that if you wish to reduce expense, lawyers are classic for obviously wanting to put everything in writing. But the only point I'm trying to make there is I'm a big fan of putting advice in writing, and I think it's important that you do that. So I just wanted to all I'm trying to say is if you're going to your lawyer to try and limit the amount of fees that you spend, then the best way to do it, in my view, is to sort of send them an email or give them instructions on what the issue is, or the documents, or send them the documents and say this is the issue. But then I find that clients get so much more value out of saying, getting the lawyer to read and consider those and get their head around it, than sitting down and spending some time in a room asking questions and saying, well, what's your view on it? A client, in my experience, will always get more value out of that than a detailed letter of advice that's 6 pages long. They've spent far more, they will have spent more money on getting that than they will have the lawyer just simply sitting down and giving them their views. And they won't be able to ask questions to the letter of advice. You know,
and the client may not necessarily absorb everything that's in that letter.
100%, because lawyers, they're getting better at writing in plain English, but there's often legalese, and the truth is, lawyers think that clients want to read 6-page letters of advice. Clients just want to know the answer. Like, what's the answer? Like, just tell me the answer. And and that's why you often give an executive summary of what the position is.
Yep. Okay. Now, tip number 6, one for you, Nick. Ask your lawyer to fix their fee.
Yeah, so 10 years ago when the firm started, this was one of the key tenets that really made it take off, and it's certainly something that has persisted through the firm even to today. So fixing fees is something that a lot of conservative lawyers maybe don't want to do, because they only see the downside risk of, if I fix my fee and I then incur more time-based billing cost, I can't then charge for it. But what we find is that if you fix your fee, the client is going to be more satisfied with the result, and they're more willing to actually engage you, because they know what you're going to charge and what service you're actually going to provide. And really, the law is a service-based industry. There's lots of service-based industries which people require fixed fees for before they'll engage someone to go do the job. And frankly, we're no different. There are some areas which help of the law which can help the fixed fee arrangement occurring, and there's some elements where it isn't appropriate. But simple first sort of engagements, such as a letter of demand in a dispute process, that could be fixed feed if you ask your lawyer and they're willing to do it. We find clients really do enjoy doing that. To Aaron's point about proportionality, for the smaller disputes, being able to issue a letter of demand on a lawyer's letterhead on a fixed fee basis can provide a proportional outcome, as opposed to time-based billing and going off and commencing a proceeding. There's also the other areas such as shareholders' agreements, the commercial documents.
Yeah. Okay, that all makes a lot of sense. And similarly, tip number 7, the fewer the lawyers, the lower the costs. Seems obvious, but probably doesn't always work that way.
It seems obvious, and I think it's something for clients to consider when they start to receive the bills from their client, when the clients start to receive their bills from the law firm, is to say, have a look at the itemisation and say, well, how many lawyers are actually working on this matter? Typically, client will come to a firm because they want the partner to work on the matter, and the partner, being in that role, won't have the ability to spend all the time on one matter, but will engage with a group of junior lawyers who are trusted to do the work. What you want to make sure of is that you've got the right hierarchy for that right task. So there'll be massive pieces of litigation, $10 million plus, you're going to want a big team on that because you need it. But if you're coming in with a $150,000, $200,000 dispute, you don't want 6 lawyers working on your matter. And being able to work through with your lawyer early about who's going to be working on this matter with you, being understanding of the fact you're not going to just get the partner's time, and trying to work to find a solution that will work for everyone is really important. And
is that an advantage, having a firm of your size, that sort of mid-level, where the client can come in, they can engage directly with directors?
Yes.
Whereas I think the big firms, they have that practice where the partners are more about business development sometimes.
Yeah. And that's not what clients want. Clients want them on their matters, using their intellectual capital on the issue that they've got. So I think that's my experience anyway. I mean, I think that's not, you can't probably apply a broad brush to all of the big firms like that, but certainly there's some partners at those firms like that.
Yep, okay. And another one for you, Nick. Tip number 8, ensure your lawyer has a competitive hourly rate.
So Mark, part of the answer to that is around what is the hourly rate, that is, as compared to the rest of the market, is it comparable? The other part about it is, for the individual who you're seeking to engage, are their skills and experience worthy of the amount that they're seeking you pay them? And I would use the example again of sort of the specialist as opposed to the GP. You'd be paying more for the specialist, but if they do it in a considerably shorter amount of time, maybe that hourly rate actually is a better outcome for you, even if it is higher than the GP, who will take a lot longer to do the role, and at the end of the day may not get you the same result.
Is there public information that people you talk about the scale of costs that's here, is that public information that people can look at?
Yeah, absolutely, and there's a lot that, from a consumer rights perspective, that clients can find on the Legal Practice Board website, on Law Society of WA website, and this is one of them. So if you were so minded to have a look at what are the current scale of costs in WA, if you type in the phrase scale of costs WA, legal professionals, you'll find it and it will come up. And there's different scales depending on the type of dispute or the fact that you're not in a dispute, so the different levels. But absolutely clients can find that information out. And the other part to remember as a client is, if you ever have a question about costs for your lawyer, they're obliged to answer it and not charge you for it. So that's also a really effective way of making sure that your lawyer is continuing to work in your best interests at an appropriate amount of money.
Okay, very handy. Rightio. Tip number 9, one for you, Aaron. Yep. Ask your lawyer to use their own precedent documents.
So the 2 things on this, Mark. Often a transaction needs to be documented by your lawyer, and there's often 2 or more parties involved in the transaction, and the question becomes which lawyer is going to draft the documents. Now, some people might think, well, it's going to be cheaper for me as the client if I get the other party to draft the documents. I'll just get my lawyer to review it when it's done. My experience is actually the opposite for 2 reasons. One, lawyers are familiar with their precedent documents. They know their suite of documents, and when, for example, if you're resolving a legal dispute, which Nick and I are always resolving litigation constantly, you have a pro forma deed of settlement that everybody signs. We've done hundreds of those documents between us, maybe more, and we know our document like the back of our hand, so we can draft it and knock it up, rather than being presented with a new document by a lawyer to review. And then that actually often takes us more time than even just drafting it from scratch from our beginning. The other thing that's really important is, psychologically, from a negotiation perspective, your lawyer's going to draft a document which is favoured towards you, and the other side's going to draft a document that's favoured towards them. So you're always going to have to negotiate back if the lawyer on the other side drafts the document and then says, hey, what do you think? You're then struck in this position of, oh, can I make this change and these changes and these changes? And then they're asking you why. Whereas the primary point is that you've got in first, really, with the changes that are in your client's interests. Yeah, so that's a big thing for me. I always, whenever I'm in a court case and they say, listen, we've done a deal, I'm always the one to put my hand up first and say, I'll draft the deed, I'll do the deed, because I don't want to deal with the other lawyer's documents.
Mm-hmm. Okay, very good. And lastly, tip number 10, know your rights. Sounds obvious, Nick, but that can be a big topic in itself.
It can be, and this goes to the matters we were just discussing a moment ago, which is around the big thing clients really want to know is cost basis and am I getting the right advice? There's absolutely no problem with clients going off and getting a second opinion. And if they ever think they are in need of it, we would highly recommend that they do it. And then in relation to your rights more generally, you've got rights around, as we were discussing earlier, costs and cost disclosure. You've got rights around when I receive a bill, can I please have the itemisation for it so I can see what you've actually charged me for doing. And then if I'm not content with that as the client, making the complaint. And the way in which the rules are set up for lawyers are heavily in favour of clients who wish to make complaints about bills. And it's important for clients to know that if they're ever concerned about their bill, we would always recommend the first, like any other dispute, go see the person on the other side and try to resolve it between yourselves, because that will be the quickest and easiest way more often than not. But if that doesn't work, you do have rights and you can prosecute them in a relatively easy way. And the information is readily available on the internet to go find it, right. How to do that.
And that's Legal Practice Board? Is that
Legal Practice Board is certainly one way to do it. Going through sort of a cost committee type review is also another. Going through the Supreme Court if you've been involved in litigation or you want an assessment of costs. That's the typical way clients will do it. So there are a number of different avenues you could go down, but certainly if you have a concern around costs with lawyers, try to sort it out with them. If you can't do that, there are cost lawyers themselves out there who specialise in the area, and you should go see one of those practitioners.
Okay. Well, look, Nick, Aaron, thanks very much for your time.
Pleasure.
Thanks, I hope everybody's found that useful. I guess in keeping with your company name, very pragmatic advice. Now, if you want to refer other people to watch this webinar, it's available through the Pragma Lawyers website, simply pragma.law, and the contact details should be on the screen. There's a phone number there. You can call Aaron or Nick or the team and talk more. Thanks very much for listening.